Hi there. I'm Matt Eastwood. I'm the Group Data Protection Officer here at Citation, and today I just wanted to talk a little bit about GDPR. So, what is GDPR? GDPR is all about how, as an organization, you handle people's data. You have to learn how to recognize a request. You may get things like subject access requests or the right to be forgotten. You have to learn how to recognize them when they come in and how to deal with them appropriately within the timeframes. It's about a concept of privacy by design. You make any changes to the organization, the way you process data, you should build in privacy as a consideration right at the start. You need to be transparent. People need to know what data you have on them and why you have that data. It's not about going out there and getting consent all which way and everywhere, but people do need to know. Staff need to be trained. It's the only way that any data protection program will be effective is if staff understand what personal data is and how they should act with that. That can be achieved through organizational controls. Some are technology based, others can be policy and process based. It's all relative, but it's making sure that you have controls in place that are appropriate for your kind of business. Most importantly, even though there are requirements that go above what the Data Protection Act originally asked back in the day, it's still the same premise. It's all about people's right to privacy and balancing that with your rights as a company to market to people and to hold data on your customers and your employees alike. So, what is personal data? It relates to an identified or identifiable natural person. Really, all that means is it's a person. Personal data is only personal if it relates to the individual. Names, addresses, email addresses, things around gender, videos and images of people. Opinions are an interesting point because my opinion of somebody is both my own personal data and theirs. And online identifiers. This has been expanded a bit now, so you have to think about things like usernames, IP addresses and cookies if they can be used with other data to identify a person. Now, sensitive personal data. It's the same now as it was before, really. It's things around racial and ethnic origin, trade union membership, genetic or biometric data, health, sex life, sexual orientation. Under GDPR, it's actually called special categories of information, but it's the same premise overall. Now, there's extra restrictions on using this, as there always have been. There's the one you always hear, explicit consent, which means if I've told you you can use it, you can use it. But there are other reasons that you might hold that data. If it's relating to employment, then you've got a valid reason to have it. If it's required for saving a person's life, their vital interest, or if you need it for defence of legal claims. There's more reasons, but all in all, it basically mirrors what current standards require. So what do you do as a business? There's a lot in GDPR and it's quite complicated at times. Well, there are simple steps any business should really take. A strategy review is always a good start. Get an idea of what you need to do, how you're going to accomplish it before the deadline, if you can accomplish it all before the deadline. Data mapping. Now, it's not required for every business, but it's the best way to go about things anyway. Understanding how your data flows, what data you've got, where it goes within the business, outside the business, what suppliers have got access to it, what staff are using it. All of that helps when you come to being transparent, giving people notification of how you're using that data. As always, you should have a retention period for documents. GDPR doesn't tell you you have to keep it for this long and get rid of it, but it does tell you that you have a reason. You have to have a reason even to hold personal data, and if that reason is no longer there, or if it's outweighed by a person's right to privacy, then you should get rid. If you use IT systems, as the majority of people do, it should be analysed. You may need additional security. You may not. It really depends on what your current levels are and what data you've got, the size of your organisation. But in any case, it's worth checking and making sure you're in a good place. An awareness campaign, both on GDPR as a whole and also how you're planning on dealing with it, how you're doing things internally, what changes are you making. People need to know. To hold the personal data, you should identify why you hold it. What's your legal basis? And the reason I say this is everyone worries about consent. And because the definition of consent's changed, people worry you can't hold data anymore. You may have valid reasons, but you need to tell people what those reasons are, and you can't do that unless you know yourself. Review your individual's rights, the right to subject access, the right to be informed, the right to erasure or rectification of data. You need to understand these so you know when you get a request how to deal with it. Put that process in place to deal with it as soon as it comes in. Have a data breach procedure. It could be integrated into any IT procedures you have, but you need to know what will you do if personal data is breached, if it's lost, if it's stolen, if it's intercepted. You've got a notification requirement if it's a serious breach. So knowing how to handle it and who's going to handle it is paramount. Data protection impact assessments are the way that effectively you'll measure the risk of any changes you make to personal data. You need to build these in at a high level, at a board level effectively. Anything that the board is considering of doing, you need to check against data protection just to make sure everything's safe. Look over your policies, your processes, if you have any. If you don't, put something together. And review your suppliers, because you've got an obligation for them holding the data. So you need to know that they're doing what you tell them to do with it and that they're holding it securely as well. So when recording any kind of data processing activities you have, you need to include who those people are, who the data is about, that reason for processing, who it's shared with, where it's stored, and why you're doing it in the first place. A good approach is to do it by activity. So have a process for recruitment, for disciplinary, for payroll, for performance review. Each of these are going to be different. They're going to use different suppliers, go to different people, but it's a practical way of mapping out in a way that makes sense to you what data you're actually using at the time. Consent is important, which is why you hear about it so much. It must be freely given, specific, informed, and unambiguous. Basically, they need to know exactly what they're signing up for, and you need to give them that information so they can make an informed decision and it be auditable. And an example being when you sign your name saying I agree to this and date it, that's clear recorded consent. You're not going to need that for core employment activities. There's no way you could live in a world where any employee could say, I don't want you to hold my data anymore, because then how could you pay them? How could you manage them as staff? There might be some activities you do need consent in an employment context. When you're looking at third-party reward schemes, that's not a key employment activity. Signing people up on a mailing list is the same, but sharing an employee's salary details with their direct manager, payroll and HR, they're all reasonable and expected within any employment context, so you'll be fine. When you're looking at data storage, it comes into two ways really. It asks for a relevant filing system under Data Protection Act, and it's the same premise here, a structured set of personal data. Now, if you're looking at it in an electronic format, everything is searchable. Everything is structured, even if they're all put together in one folder, hidden away, it's still searchable due to the nature of technology. So if it's on a computer, it's going to come under data protection. Manual files, however, it's a bit more complicated. A Standard HR department probably has printed out records of employees. If they're in folders or in cabinets that are labelled CVs and are organised in some way, or if they're organised via the employees' names, then they're in a structured system. They're going to come under any request for access. If you're like me and you scribble notes all over the place and you've got them collecting in your top drawer, however, that's not structured. That's not in any kind of real filing system. You're never going to know to search there. So that wouldn't come under GDPR. Of course, there's always an argument to say that if those notepads went all over the place and you threw it away and it was found and it had a load of medical data in it, you'd be in trouble. So even though it's not covered as such, you should still be reasonably protective of any personal data nonetheless. So when we say secure, we mean avoid people being able to get to it if they don't have authorization. You should avoid theft, accidental loss, destruction, damage. Now, data protection and GDPR all say appropriate measures should be taken, and they don't give any real guidance on what appropriate measures are. So a little bit of common sense is required in this area. And that comes down to how big an organisation you are, how much money you've got at your disposal, how much personal data you hold, and how sensitive that data is. A large organisation processing thousands of medical records is going to require secure IT systems. A small two-man, three-man band, however, that just holds some employee data, then all you need is lockable storage, maybe some encryption when you're sending things, make sure things are password protected. A lot of this stuff can be free, so you just have to be reasonable, take an appropriate step. The Information Commissioner is known for going after people if they don't encrypt their data when emailing it, so even so far as putting it in a password protected zip file is a reasonable step in the right direction. Some of you will know about data protection officers. I am one myself. My job is to inform, advise both the board, the employees and my customers on our data protection obligations as a company. The DPOs out there monitor compliance with data protection law and are the first point of contact for people like the Information Commissioner's Office when any complaints are raised or if we need guidance ourselves. Now, the new requirement for data protection officers is interesting because a DPO must act without conflict of interest. They need to report to high-level management and need to be independent to the business in a lot of respects. That doesn't mean you can't have an employee. It also doesn't mean you can't outsource it, but they need to be able to do their job without feeling like they're either monitoring themselves, which obviously they can't do, or their judgment is being impaired. So one of the worries people have at the moment is the mandatory breach reporting. Within 72 hours of any data breach, people think they have to report to an Information Commissioner's Office. Now, that only applies if it's a significant risk. So you don't have to report every missent email. But if a large quantity or a lot of sensitive information, or just even if it's a small amount of really sensitive data goes out into the world, you may have to report it. From the 72 hours of finding out about the breach. It's not from the point of the breach, it's from becoming aware. How else could you be expected to meet the obligation if you only find out a week later? You might have to notify people, the data subjects, the customers, the employees. The real step you should take upon even suspecting there's a breach is just have a look, do an investigation, find out if you can find out where the data went, find out who it went to, find out if you can recall it, delete it, take reasonable steps, and then see if you've got a requirement or not. I mentioned earlier transparency, and it's almost like the websites that you see at the moment. They have a little privacy notice at the bottom saying when you visit our website, we will use your data in this way or that way. It's that to a new level, effectively. Employees need to know what data you've got, so do clients, so does anyone visiting your website. Now, a fair processing notice to be GDPR compliant needs to outline all the reasons why, where the data comes from, the legal basis surrounding processing that data, who it's shared with, but also they need to be informed at that point what their rights are under GDPR. So that right to access, that right to rectify that data needs to be given to them at the point you collect data, if you can, or at a reasonable point when not. Also, how someone to contact. Not everyone will have a DPO, which is fine. In citation, I'm the main point of contact for one of these kinds of questions. If there's no DPO, just have an email address, somebody that can be contacted. Because even if you don't have to have a DPO, you still have to respond to these types of requests. The rights that people have, as I've mentioned, there's the right to access their own personal data and the right to have inaccurate data rectified. Now, when you're talking inaccurate data, you have an obligation as a controller to make sure that data is accurate, but you can't be expected to know everything. Therefore, it's sensible to provide employees and customers tools to update their own information and to check, remind them. But you can't be expected to know everything, so it's putting those mechanisms in place. People could ask to have their data erased when it's no longer necessary, which is effectively the right to be forgotten. There's a lot of confusion around this at the moment because people don't understand the situations where it applies versus when it doesn't. Where processing is based on consent, people can take away that consent. Therefore, if they ask you to delete that data, you probably should. However, if you've got a legal purpose for holding that data, how can you be expected to delete it? There are exceptions, there are rules to follow around this. All I'd say is don't worry about it. Take a bit of time to understand what those requirements are and just put a little process together to understand that each request needs to be reviewed in its own merits. Don't make assumptions that it can or can't be deleted, but remember there are a lot of reasons why an organisation might need to keep that data. Now, if someone asks for their data, it needs to be made available in a particular standard. This is called data portability. This is normally in cases around contractual obligations. If you process someone's data as a client, then when you terminate your agreement or they terminate the agreement, they may have the right to have that data in a format they can take to another supplier. Example of this is the energy industry, your gas and electric. You may want to change supplier. At that point, if you requested they give you your data, they have to do so in that standard format, things like Excel files. There's the right to object to direct marketing. Everyone knows that this exists anyway, but it's just clarifying that. Make sure people know that they can opt out. Give them the opportunities to opt out. And the last and most interesting one in my mind is the automated decision making. Not many people use automated decision making too often, but it is around. People do it for psychometric tests when employing staff. They do it for credit checks. Now, if it relates to an individual, they have a right to say, I don't want you to do that. and you'll have to find a manual, personal way of making that decision. So just be aware and make people aware of the fact that if they're not happy with the automated decision making, they can object. They also can ask for the logic behind any automated decisions made about them. You probably have a lot of questions. The first point of call should always be the Information Commissioner's Office. Their website is on the screen. They also have a helpline which they've set up specifically for small businesses that don't know quite where to start. So it's definitely worth giving them a call, finding out a bit more. They're there to help. Keep an eye out on the stuff we're providing as well. We are creating more and more little guidance documents that we publish through Atlas. We've got the Getting Ready for GDPR e-learning course, which we will be updating after GDPR to be a full training program. For now, this will not only give staff an overview of their obligations, but also your organizational obligations. So it's definitely worth checking out. And don't forget, we offer a GDPR readiness assessment through QMS, which if you're struggling to find out where you're currently at compliance-wise, it's definitely worth considering. Thank you very much.